My name is Paul Sokolowski. I'm a partner and the tax practice leader at Arnold Block Leibler, and we're very happy to be presenting our webinar series, Quick Takes on Tax, over the next 4 weeks. Welcome to all of you situated in many parts of this big brown land. We pay our respects to the traditional owners of this land and their leaders, past, current, and future, from whom we can learn the wrongs of history and the ways we can work together in a movement of the Australian people for a better future. Before I introduce our speakers this afternoon, some further housekeeping. Your video and audio will not be enabled during the session, and you will not be visible to anyone else on the webinar. We will take questions at the end. If you have any questions, please use the Q&A button at the bottom of your screen, and we'll get to as many questions as we can, as time permits. It was a long time ago, and it was written, that the trust was the queen of the tax planning chessboard, and with the passage of time and with it legislation, judicial decisions and administrative action, we can now doubt that statement. Now it seems the trust is less the queen and more one of the lesser pieces. In time, we may ask, will it become a mere pawn? To take us through what appears to be a fraying of the trust supremacy in an international tax context, I have great pleasure in introducing our presenters today. In order, Andrew Spierings, a lawyer in our tax team, Greg Judd, a senior associate in our tax team, and my partner, Clint Harding. Andrew, Greg, and Clint, let's have a conversation about international issues with trusts and CGT.
Thank you very much, Paul. The purpose of today is really to go through broadly some of the topical issues in this area. We'll begin by putting ourselves in the position of the Australian trust with foreign beneficiaries. First, by looking at the Federal Court's recent decision in Greensill, which has attracted some attention. Greg will then take us through some of the more recent ATO publications on that issue, as well as some others. We'll then move to the foreign trust with Australian beneficiaries, and Clint will take us through some of the issues around Section 99B that are circulating at the moment, and we'll also deal more broadly with some structuring considerations and tax treaty overlays. Turning first then to the Greensill decision. This case is concerned with the accessibility of capital gains made by a resident trust from non-taxable Australian property assets, which are then streamed to a non-resident beneficiary. Pending an appeal, it's now clear that they will be subject to tax. I'm sure you're all fairly familiar with the broad structure of the provisions, but they can be a little dense, so I'll recap them briefly just to set the scene. We have, of course, Division 6 of the 1936 Act, which assesses trusts and beneficiaries on net income. That's then adjusted by Division 6E, so that the trust can stream capital gains and frank dividends. In the case of capital gains, Subdivision 115C of the 97 Act adds an amount to the income of the beneficiary. It grosses up the capital gain and allows the beneficiary to then apply the CGT discount and any of their own capital losses. Where there's a non-resident beneficiary, the trustee is then assessed under Section 98 on the beneficiary's share, and the beneficiary gets a credit for the tax paid. This is a Section 98 assessment. We also have Division 855 of the 97 Act. It contains a regime regarding taxable Australian property. Broadly, that's direct or indirect interests in Australian real property or assets used in a permanent establishment in Australia. In the past, people would have said that Division 855 is broadly intended to tax non-residents on gains from TAP assets, but not on other gains. In light of Greensill, that's not entirely true. And the most important provisions for our purposes are 855.10 and 855.40. 855.10 disregards the gain made by a non-resident on non-TAP assets. 855.40 is in similar terms, but it is expressly dealing with beneficiaries of fixed trusts and the gains that are arising in respect of those interests. Turning to the facts at hand, the Peter Greensill Family Trust is a discretionary trust and it's resident in Australia. The trust then owns shares in Greensill Capital, which is an Australian company, but its shares are non-taxable Australian property. Greensill Capital owns various other entities in Australia and overseas. The group's in the business of supply chain financing and apparently did around $150 billion worth of business in 2019, just for an idea of scale. It was founded by Lex Greensill, who's a UK resident. Greensill Capital was established in November 2011, and the trust was issued with 100 ordinary shares. There have been various splits and conversions over the years, ending up with millions of shares with a minimal cost base. In 2015, 16 and 17, the trustee disposes of various parcels of shares, of course an A1 event. And in 2017, there's also an in-specie distribution to Lex Greensill, which is an E5 event. Those gains are in the tens of millions of dollars, as you can see, and 100% of the gains were streamed to Lex Greensill. The taxpayer's argument was that these gains should be disregarded under 85510. And the taxpayer said, when subdivision 115C refers to an amount in relation to a beneficiary, it's also referring to a disregarded amount. And they say, well, 85510 would definitely have applied if Lex Greensill had owned the shares directly. And 85540 would definitely have applied if this was a fixed trust. And the taxpayer says it's absurd if 85510 doesn't apply in this case. And it points to the perceived policy of 855 and says, well, non-residents are not supposed to be taxed on non-tap gains. However, Justice Thorley, sitting in the federal court, rejects this argument. And he deals first at the trust level and he says, well, the trust makes the gain and 85510 doesn't apply at that level because the trust is a resident. And he turns then to the beneficiary level and he says 855 doesn't disregard subdivision 115C amount. All 115C does is makes a calculation and adds that amount to the assessable income based on the trust gain. It's a calculated amount. It's not a gain itself to which 85510 can apply. He then turns to the particular words of 85510 and he says the amount is not from a CGT event. He takes a fairly orthodox textual approach to the legislation and he looks to subdivision 115C, which refers to an amount in relation to a beneficiary and an attributable gain. It's this sort of language throughout the subdivision. In comparison, the from in 85510 requires a causal connection. Justice Thorley says that's a connection that's greater than in relation to or in respect of. Rather, it's a direct connection. And then he compares that to 85540, which uses attributable to a CGT event rather than from a CGT event. He then cross-checks that against other provisions, particularly the approach in section 102.20, which is about ways you can make a capital gain. He looks to note 3 of that section, which is about making gains as a result of an event happening to another entity. Contrast that with note 6, where a gain arises from a CGT event in certain circumstances to do with hedging arrangements. He then deals with this absurdity argument and reinforces the consolidated media holdings orthodoxy, that is, look to the text for intention rather than looking for what you think the intended purpose is and interpreting the text through that lens. He was quite critical of the taxpayer's approach in that regard. He was standing very firmly in the text and looking to those words as well as the words of the surrounding sections. His Honour was very comfortable that 85510 applied in that way. because it was the only way that 85540 would have any work to do. That was, of course, particularly about fixed trusts. If 85510 can apply to any beneficiary of any trust, then 85540 is redundant. The way Justice Thorley dealt with the E5 event, the in-specie distribution, I think illustrates particularly well the operation of 85510. In an E5, the trustee makes a gain, but the beneficiary also makes a gain. The trustee's gain flows through to Greensill in the same way as the A1 gains. It's dealt with under 115C and it's not disregarded. However, Lex Greensill's gains are from a CGT event and he's a non-resident, so they are disregarded under 85510. Now, the taxpayer has lodged an appeal, which is yet to be heard. In the last few weeks, we have also had another decision on point, which is N&M Martin Holdings. In that, Justice Stewart followed Greensill. As a matter of precedent, His Honour considered that single judges of the Federal Court should follow each other when dealing with the same provisions, unless the decision was plainly wrong, and he emphasised how high that plainly wrong bar is. But in any case, Justice Stewart expressed agreement with Thorley's reasoning. You might say, in glowing terms, this was just one extract which proves Justice Thorley's decision. There is one paragraph towards the end of Justice Stewart's decision which says that the taxpayers' submissions there have much to commend them if only looking at the language of 85510. However, in the context of the other provisions, His Honour didn't think the section could be read that way. Even so, that one paragraph may well still encourage an appeal. Justice Stewart's comments are also quite interesting for the prospects of the Greensill appeal. Given that there are only a handful of specialist tax judges, he may well be sitting on the full court, and we clearly know his view on how 85510 operates. Of course, it remains to be seen how all of these issues will be handled on the appeal or appeals. But we now have a clear view from at least two federal court judges, which gives us a degree of certainty that we did not have before. And it clearly warns us that people can no longer expect to stream non-tap gains to foreign beneficiaries without incurring tax. And that certainty is definitely welcome. I will hand you over now to Greg Judd, who will take us through a few of the ATO's recent publications on this issue and some other related issues.
Thank you, Andrew. It's a good spot to land and a nice segue to talking about some of these ATO products that we've seen more recently. I'll go through TD 2019 D6, D7 and Taxpayer Alert 2023. I say it's a nice segue because these cases, Peter Greensill and N&M Martin Holdings, really affirm the Commissioner's position in draft TD 2019 D6 almost verbatim. To understand a taxpayer perception that these may be unintended consequences, it's useful to consider some of the key history and context to these rules. In 2004, Parliament enacted former subdivision 768H, the predecessor to 85540, so that non-residents investing in Australian assets through Australian managed funds were not taxed more than if they invested directly in those assets or through a non-resident fund. The subdivision was aimed at improving the international competitiveness in Australia for managed funds and increase their attractiveness to foreign investors. At the time, Parliament expressly limited that concession in 768H to a beneficiary of a fixed trust. The 768EM stated it was appropriate to include fixed trusts because a foreign resident would not be assessed on such a gain if the asset were held directly The EM also stated that requiring a fixed trust provided integrity and ensured the trustee had no discretion to provide benefits to parties who were not beneficiaries of the trust. Tax laws evolved since 768H. After Bamford in 2010, it was not clear how the High Court's proportionate approach interacted with capital gains and frank distributions, or whether they could retain their character in the hands of a beneficiary. Amendments to 115C were then introduced in 2011 to essentially allow the effective streaming of capital gains and frank distributions to beneficiaries. This all raised the question, could 115C and 855 be read in line with a policy that treats trust as a conduit? A policy that doesn't tax foreign resident beneficiaries on capital gains arising from CGT events happening to non-tap assets of a non-fixed trust. These cases essentially say no. Stuart J thought the 768 HEM strongly indicated Parliament's intention to exclude non-fixed trusts. Thorley J said the 855 EM did not suggest that Parliament intended to reverse the decision. The courts are correctly focusing on the black letter law. Thorley J pointed us to the caution expressed in the case of certain Lloyd's underwriters against Cross in 2012. He noted the danger in construing a statute to coincide with an assumption about its purpose. He said that was the wrong order. The inverse is the correct approach. The purpose is derived from what the legislation says, not from an assumption about the desirable operation of provisions. If these are unintended consequences, note the second reading speech about the 2011 streaming measures, where the Minister said the government is aware that due to the short time frame involved in developing these amendments, there may be scope for unintended consequences. The operation of these amendments will therefore be closely monitored, and if unintended consequences are identified, the government will act to remedy these consequences retrospectively where appropriate. I guess we wait to see if the government identifies these as unintended consequences and would act to remedy them. Let's go to TD 2019 D7. Where a non-resident beneficiary is made presently entitled to all or part of an Australian trust's net capital gain, Section 115.220 makes that part assessable and taxable to the trustee under Section 98. Section 98 contains a source concept, limiting the assessment of non-residents or trustees to amounts attributable to sources in Australia. In the Commissioner's view, that Section 115.220 does not test whether the beneficiary's attributable gain satisfies the conditions of Section 98, and the source concept is irrelevant to the operation of Section 115.220. What does that mean? This means a foreign resident beneficiary of an Australian trust is assessable on non-tap gains even if the trust property has nothing to do with Australia and the gain is not Australian sourced. We are yet to see this tested in the courts, but it's worth considering some technical points about or around the statutory interpretation and the context. Note Section 610(5), subsection 5, which states that a foreign resident's assessable income includes their statutory income from all Australian sources and other statutory income that a provision includes in their assessable income, and the wording is on some basis other than having an Australian source. Query whether 115C should be subject to Section 610 so that a non-resident beneficiary's share of a capital gain of a resident non-fixed trust would not be subject to Australian tax unless the gain has an Australian source. that interpretation would give effect to the literal words of subsection 610(5). This is really the heart of the matter. The Commissioner says that 115C does include statutory income on some basis other than having an Australian source. He points to the 610EM comment that capital gains and loss provisions bring to account gains and losses on the disposal of a taxable Australian asset rather than on Australian source capital gains and losses. Let's consider these. Section 102(5) includes a net capital gain, inaccessible income, as a form of statutory income. It does not by itself prescribe a basis for that inclusion. This raises the question as to whether 610(5) either applies to the entire net capital gain, has no application to CGT at all, or applies to the different amounts that a net capital gain is comprised of. Section 610(5) should not apply to the net capital gain. A net capital gain is an artificial construct which does not by itself have a source. The Commissioner agrees with this. And recently, on 26 August the Commissioner in Tax Determination to 2027 said that his view was that the relevant statutory income is a taxpayer's net capital gain and that a net capital gain does not have a source. Arguably, if the CGT rules, non-residents of the beneficiary, residents of the trust are not a relevant basis under Section 610, then 115C would not prescribe any relevant basis for distinguishing capital gains of a trust and whether they are included in a beneficiary's net capital gain calculation. So if the Commissioner considers that 115C capital gains do not arise from CGT events, he may accept that paragraph 610(5)(a) applies so that only Australian source 115C capital gains of a resident non-fixed trust should be included in calculating a non-resident beneficiary's net capital gain. I'll just finish on TD 2019-D7 by commending the Commissioner's administrative position in relation to 2019 and earlier income years, not seeking to disturb approaches taken for capital gains from non-tap assets of the trust, which are consistent with source principles in the pre-2011 streaming legislation. I'll just spend a few minutes on Taxpayer Alert 2023, published on 14 August. The TA outlines ATO concerns about offshore-related entities being used to avoid interest withholding tax. The diagram on the slide you see sets the scene. A resident trust derives income which the trustee distributes to an offshore interposed corporate beneficiary. The trustee pays tax on the distribution of the corporate rate under subsection 98(3). The beneficiary is partially funded with high interest rate related party debt, usually with no traceable third party debt. This creates significant interest deductions for the beneficiary against its Australian income in the tax return, giving rise to a refundable credit for all or almost all the tax already paid by the trustee. The non-resident beneficiary is claimed not to be carrying on a business through a PE in Australia. No interest withholding tax liability arises. The ATO is concerned that these arrangements may lack commercial rationale and may be entered into to avoid interest withholding tax liabilities. The ATO points to relevant regimes that could operate in these structures. One is transfer pricing. If we look at the debt funding between the corporate beneficiary and the lender, transfer pricing rules may seek to adjust the interest rate charged between those parties to be an arm's length interest rate. Thin capitalisation could operate here, looking at the corporate beneficiary's debt to equity structure. Again, thin capitalisation rules may limit or deny deductions where that entity is too heavily geared or thinly capitalised. The related scheme provisions in Division 974, the debt equity rules, may also be relevant here, looking at the nature of this instrument. And the related schemes provisions may look through the two tiers as well to see if there's an overarching scheme that may be reclassified as debt or equity and having the relevant implications on the returns, having been then classified under those provisions as interest or really a dividend. The Commissioner also points to the general anti-avoidance rules, and that really is just a summary of some of the things the Commissioner is looking at in those structures. And again, that taxpayer alert is focusing on avoidance of interest withholding tax. I think I'll leave it there. Those are just three products giving us an update on some of the thinking of the Commissioner in more recent times, and I'll hand over to my partner, Clint.
It's a miracle. I remember to take myself off mute. Thanks, Greg. And can I just say again, thanks to everyone who's joined us today. I think if you live by the saying, the best things in life are free, then I figure this ABL tax webinar is right up there with the birth of a child or playing with a new kitten. Today could well be one of the greatest days of our lives. But I guess just quickly on a more serious note, I did want to acknowledge the hard yards being done by our colleagues and friends in Victoria who are still in stage 4 lockdown and are doing it pretty tough. So I'm sitting up here in Sydney, but my thoughts are with you all, and I hope you stay safe and well. And I look forward to catching up with as many of you as possible when we can resume something resembling a normal life again. So Greg and Andrew have taken you through Greensill and a few of the Commissioner's recent determinations sort of focused on Australian resident trusts. I thought what would be useful to finish off this session was sort of flipping that on its head and talking about distributions of capital gains from non-resident trusts to Australian resident beneficiaries. And I think this is worth talking about because in 2017, as some of you may know, the Commissioner issued a tax determination, or actually two. It was TD 2017-23 and 2017-24, but both concern the same issue. That at least I thought were counterintuitive, but the technical position taken by the Commissioner is consistent with the interaction of 855 and 115 that we've talked about already today. As Paul referred to when he talked about chess, it's been a long tenet of Australian tax folklore, as confirmed going back to the High Court's decision in Charles back in the 1950s, before I was born. It is my birthday today, actually, but I wasn't born in the 1950s. The decision in Charles that the interposition of a trust between an income source and a beneficiary does not change the character or source or timing for tax purposes. And that was always thought to simply follow the position in equity that a trust is just a relationship over identified property. That no longer seems to be the case. So if I take you to determinations now on distributions from capital gains to resident beneficiaries by non-resident trusts, the first step in that is, what is a non-resident trust for these purposes? That's the first gateway you need to think about when you're looking at this or considering it. A resident trust for Australian purposes means a discretionary trust where the trustee is an Australian resident or the central management and control of the trust is in Australia. And for a unit trust, either the property of the trust is in Australia, it carries on business in Australia, and either its central management and control is in Australia, or Australian residents hold more than 10% of the units for present purposes. Now, that immediately points to the first pressure point when looking at this scenario in terms of you need to determine the residence of your trust. And that can be itself a complicated exercise and is worthy of a session on its own. But for those of you who are well aware of it, you'll know the Commissioner's position certainly on central management and control has changed following the release of his new rulings off the back of the Bywater decision. So that's can be an interesting issue in itself. But going back to the trust issues, what the ruling or the determination puts forward is the view that where a non-resident trust for CGT purposes makes a capital gain from the disposal of non-TAP assets, so again, that's assets without a link to Australian real property, that non-resident trust is required to disregard the gain under 855 because 855.10 specifically says so, and it's the trust's gain, and the trust itself is non-resident, so we don't come up against the same difficulties we had in Greensill there. But the Commissioner confirms 855 10 operates on its terms, and the important bit here is that is despite the fact that we in Australia have a residency assumption that usually applies to foreign trusts, that is section 95, which tells you to calculate the net income of a trust as if it were an Australian resident. The Commissioner takes the view on those determinations that 855.10 is the more specific provision that says if you're a non-resident trust, you disregard the gain. So that's more specific than the section 95 provision that requires you to calculate net income as if you were Australian, and therefore affords priority to the more specific provision. What does all that mean? That means as a result, that capital gain is not included in the trust's net income by operation of Division 855. Now that's all a very nice technical discussion, but it actually has pretty drastic flow-on implications. What it actually means is that if that gain isn't in the net income of the trust, where is it? And what the Commissioner says is that when that trustee distributes that gain to an Australian beneficiary, it triggers another provision, section 99B, as an amount paid to or applied for the benefit of an Australian beneficiary. We're going to deal with section 99B, which is in our next session next week. So I would encourage you, if you're interested and you haven't already registered, to my prop for next week, tune in next week when Jonathan Ortner and Peter Scott will discuss all things section 99B and transfer of trusts. But for today's purposes, it's sufficient to note that section 99B says that distributions made by a non-resident trust estate to or for the benefit of Australian resident beneficiaries are assessable in the hands of those beneficiaries. And there's various exceptions to that broad rule, such as where that distribution is corpus of the trust estate, or more importantly, where the amount that's being distributed has been taxed or is liable to tax in the hands of a beneficiary or the trustee under Division 6. Where the problem starts is that because we've said, or the Commissioner says, that the gain is disregarded by 855.10 and the trustee is not taxed on it, and Division 115 doesn't treat the beneficiary as having made the gain, none of those exceptions to 99B are enlivened. And therefore, if you apply that view, the result is the Commissioner's view that the amount that's referable to the capital gain made by the non-resident trust is included in the Australian resident beneficiary's income under section 99B. What does that mean? What it really means is that if that beneficiary has capital losses or would otherwise seek to apply the CGT discount of 50%, they're out of luck because it's not a capital gain, it's a 99B amount. So putting that in diagrammatic form, Andrew, if you can flick to the next slide, if we assume just for the moment that we have a foreign trust selling shares in, let's say, an Australian company, it could be a foreign company, just assume that those shares are non-tap assets, and it makes a $50,000 gain and distributes that to an Australian resident beneficiary. If we assume for the moment that that beneficiary had, let's say, $40,000 of carried forward net capital losses that it could otherwise apply if it held the asset and sold it directly, what the outcome is that instead of having a capital gain, that beneficiary must include that $50,000 in their assessable income under 99B and can't reduce it. What that actually means in terms of numbers, and as many of you are better with numbers on the webinar than I am, but by my basic maths, means that you pay, let's say, paying tax at 47 cents in the dollar, or approximately 50%. That means about $25,000 of tax on that gain, as opposed to if you'd held the asset directly, applied your capital losses to have a $10,000 gain, applied the discount. Well, hang on, I better be careful here. I don't know whether you apply the discount. I think you apply the discount after the losses, and you have a much lower tax bill, drastically so. So that's a bit of a sleeper one, and something everyone needs to be aware of when we're dealing with foreign trusts. And I dare say will put potentially some pressure on whether a trust is resident or non-resident, depending on the outcome that arises. Andrew, if we can just flick to the other few things I wanted to say before we turn to questions. And really that was just about some of the considerations given what we've talked about today when you're structuring with trusts and considering whether you should use a trust. There's a wide range now of things you need to think about following Greensill and the various tax office views that have been talked about. You need to think about whether your trust is a resident or not, and I briefly touched upon what those tests were, but again, they can involve complicated questions of central management and control. You need to consider whether your trust is fixed or non-fixed. Again, that's worthy of an opera in and of itself. That involves concepts such as vested and indefeasible interests, and obviously that can impact on the outcome under Division 855, as Andrew and Greg talked about. You need to think about the character of the gains or the income that's going to be derived by the trust. Is it going to be a capital gain, or is it going to be some sort of other ordinary income? How does that impact on the sort of the modelling? What's the residence of the beneficiaries? And that's a hard one. No one has a crystal ball, so that can be hard to, you can set up a structure with the best of intentions, and then 25 years later, as my mother found out, no one lives in the same country as you and your family. And then also you've obviously got to throw into that questions of the tax treatment of those distributions and the jurisdiction of the beneficiary if they're in a foreign jurisdiction, and whether or not they get any tax credits. And then the fun really starts. If you really want to get interesting, then you have to think about tax treaties. And Australia has about, I think 47 or 48 with the Israel Treaty now, bilateral tax treaties with other countries, and Australia is also a party to the Multilateral Treaty Instrument, or the MLI. Most of those double tax agreements that we have, including the UK, for purposes of the Green Sill case, contain articles dealing with gains arising from the disposal of assets. They have articles dealing with taxation of business profits. They have other income articles that sort of act as a mop-up for things that aren't specifically dealt with. And so you have to really think about all of those in the context of the trust and the beneficiaries and the tax outcomes to determine whether or not that treaty impacts on Australia or the other jurisdictions' prima facie taxing rights. Whether those treaties end up with a position that one country can tax as well as the other country, or whether only one country can tax that amount. The treaty issues weren't addressed in any way, shape or form in the Green Sill decision. I presume that's because in Mr. Greensill's circumstances it wouldn't have advanced his position. But depending on other jurisdictions and other treaties, it's something you want to think about. The MLI, which I've put in that slide there, an extract of Article 3.1, which specifically, based on OECD model wording, but specifically seeks to deal with transparent entities. So as that comes online and is adopted by more and more countries, Australia's adopted it, but has preserved their existing bilateral rules where appropriate. But you'll need to give some thought to that. You can spend a bit of time with a bottle of wine and an open log fire, musing around whether or not Article 3 of the MLI, had it been applicable to Green Sill, would have changed the outcome. I don't know. I don't think it does. I don't think Article 3 conclusively resolves which country has taxing rights. It does talk about transparent entities, but it also talks about, limits that to the extent the income's treated in the other jurisdiction as income of a resident. In the UK, having lived there for 4 years and knowing a little bit about it, the UK has some remittance-based taxation rules that mean that in some circumstances UK residents aren't taxed on offshore income until it's remitted to the UK. So that may impact the treaty position. So as I said before, you need to think about all of that. And again, business profits articles, if it's ordinary income, that can change the impact of the treaty as well. So all of those considerations at the end of the day play a part, and ultimately finding the right structure is a balancing act between all of those. And if all of that gives you a real headache, then as Paul said in his introduction, perhaps that signifies a movement away from using at least discretionary trusts in international tax planning purposes. But we'll see where we go. A lot of the things we've discussed today, I think, are inconsistent with what Australia's policy on international taxation of trusts and gains generally should be. You can get to a technical position. Whether or not that's the right position for Australia to take is another question for another day, but we need to get to the end of Green Sill and Martin to really get stuck into that discussion. But listen, it's 12:40. I think we've got 5 or so minutes for questions. I might hand back to Paul with my thanks to Greg and Andrew for a great session. And maybe, Paul, you can, hopefully someone's still alive at the end of all of that who's shot through a question in our Q&A box.
No doubt about that, Clint. Thank you very much, Clint, for that. We do have a couple of questions in the remaining time we have with us. For those who want to pop in a question in the Q&A, please do so. Otherwise, just reach out to any of us if you have any queries about this topic over time. One question, perhaps I might direct to Andrew, is in circumstances with Greensill where there's an assessment issued to the trustee under Section 98, is there also an assessment that's issued to the beneficiary, in that case the non-resident, Mr. Greensill?
Yes, there will be. There'll be a Section 98A assessment made to the beneficiary. Then what you have is an assessment for both the trustee and beneficiary, and the beneficiary gets credit or whatever tax is paid by the trustee. The rationale behind that is that it's much easier for the Commissioner to recover against an Australian trust than pursue a foreign beneficiary in a lot of circumstances. In that way, it operates almost like withholding tax. Of course, it's not actually withholding tax, but it has a similar sort of purpose.
And Paul, that's at the heart of the taxpayer alert that Greg was talking about too. That's acknowledging that the trustee and that taxpayer alert will withhold at the appropriate rate if it's 30% for a non-resident corporate beneficiary, and then that corporate beneficiary will lodge a return and get a credit for the tax paid by the trustee. But in that structure, they've effectively artificially inflated all of the deductions because it files a normal return, so it can claim, unlike a withholding tax on interest and royalties and dividends, which is a final withholding tax, that non-resident beneficiary can lodge a return and claim against that income in any deductions as if it were an Australian resident taxpayer. And to the extent that it should have paid tax of a lower amount, it can get a refund of that tax paid by the trustee.
Indeed. And what's posed to us is perhaps a thought experiment, Clint. What if, in circumstances like Greensill, it wasn't a capital gain we're talking about, but a revenue gain? Does that introduce any other interesting issues that are worthy?
Yeah, absolutely. And as I said, I think it's something that people will be giving a lot of thought to with the various permutations. Obviously, bear in mind too that just because something is ordinary income doesn't mean for Australian purposes it isn't also a capital gain. So there's an interesting position where you might get to, for example, if you could get to a position where you are comfortable that the business profits article applied, noting that that's submissive to the alienation of gains article in Article 13 because it's more specific. But let's assume you get to a position where you were happy you carried on an enterprise, you didn't have a PE in Australia, and that the ordinary income was protected under the treaty and subject to tax only in the UK. There's an interesting question then, what happens if even then, if you're not taxed as ordinary income on that, whether or not the capital gains tax consequences in Australia still work, because you've got the anti-overlap provisions in 11820 that say to the extent that you include an amount, you reduce a capital gain to the extent it's included in your income in other ways. But so there's an interesting thought process there, but it's not immediately clear, and it's certainly something that advisors will need to grapple with. I'm not sure how easy it is to say you're carrying, and the interposition of a trust in the middle of all of that, where the assets being disposed of are assets by the trust, where you as a discretionary beneficiary merely have a right to be considered. How you say that's part of carrying on an enterprise, I think it's a difficult hurdle, but depending on the facts and circumstances, you may get there.
Thank you, Clint. Always useful and interesting to consider counterfactuals. Our time is nigh upon us, so I just thought I would close. We'll take a few moments to close the session. Thank you very much, Clint, Greg, and Andrew. That was a marvellous session. Andrew reminds us that the text of the legislation is supreme and that appeals to policy will not be a fruit if the policy cannot be discerned from the text, which is a golden thread that runs through all of this. Greg reminds us that history and context of legislative development are nonetheless important, but again, the words of the provisions are what matter at the end of the day. And importantly, the ATO will be on the front foot in setting out its views of law in areas of uncertainty that will not be of benefit to taxpayers necessarily. and they're very active in that space. Clint firstly equates a tax webinar with the birth of a child, a proposition that will interest some people. Happy birthday, Clint, by the way. Then Clint reminds us that as the song goes, you don't know what you've got till it's gone. And relevantly, the incremental development of the CGT rules and CGT streaming rules appear to pave the trust paradise to put up an unappealing parking lot. Just a reminder that we have 3 further tax webinars in the pipeline. The next session on Section 99B and Transfer of Trust on the 16th of September with Jonathan Ortner and Peter Scott. Then we have a session on Section 100A, the Phantom Menace, on the 23rd of September with Caitlin Loudon and myself. And finally, to bring it home, we have a session on the New South Wales and Victoria state taxes and the FIRB topical issues on the 30th of September with Zoe Chung and Mark McRae. Thank you all very, very much for spending time with us at this ABL webinar. Join us for the forthcoming webinars again. Stay well, stay healthy, and we hope you'll all join us again soon. Thank you very much.